My name is Mulwa. I'm the CEO of Solian, an investment company based in Kenya with offices in Mombasa and Nairobi. I'm also a practicing advocate, mainly practicing conveyancing and land law. If you like to buy property in Kenya, the first thing you need to do is first identify the property, view it, and then you need to obtain the necessary documentations, both to do due diligence on the owner of the property and of the property itself. First, to conduct a due diligence on the owner, you need to basically know who you are dealing with. And the first you need is copy of their ID and PIN registration, that is KRA PIN registration. If they are a company, then you require their certificate of incorporation and PIN certificate. For the property, you need a copy of the title, you need a copy of the lease, you need a copy of the deed plan if it is a title that is registered under the Registration of Titles Act, or you need the RIM map if it is a title registered under the Registered Land Act. Once you have those documents, then we advise and encourage that you have a conveyancing lawyer who will then take you through the due diligence process. Due diligence process starts with first check who the owner of the land is, ask around, find out their brand, what is their brand, who are they known, are there referrals who can refer you to this kind of person. And then using the identification documents, you can check the authenticity of the documents provided. First, you can check whether the PIN is okay. There is what we call a PIN checker at KRA. You can check whether the PIN provided confirms and conforms to the names that have been given. You can also be able to check the ID, that the ID provided corresponds to the person that has given you the ID documents. If it's a company, then you can do a search at the company's registry. And the good thing now is the government has basically rolled out a very digital process. You can do this at the comfort of your desk through your eCitizen account. And you can check who are the owners, who are the directors, what is their shareholding. And then from there, you at least have an idea of who are you dealing with. Identify the property. Hopefully by this time you've already gone to the ground, you've checked the beacons, the boundaries. So what remains is for you or your lawyer to check the ownership of the documents. At the land registry, you'll be able to apply with a copy of the title, copy of your ID, and at times they require your PIN certificate. Apply for the search, pay the required government fees, then they will be able to provide for you an official search that shows who is the owner of the land, what is the size of the land, and the location of the land. Depending on what kind of title you're dealing with, because we have different kind of titles, you'll be able to see the size of the land. You'll be able to also check. You can be able to check the green card, get a copy of it, or you can get the title register. All these provide for you a history of the land. You can be able to see who has dealt with that land, what transactions have been done on that land. Does this land have a loan? Does it have a charge? Are there any encumbrances? Are there people who have put in caveats on it? All this you can be able to check. And the registrar will be able to give you a signed copy showing what is the status of the land you're buying. As you conduct a due diligence, there are obvious costs that are involved, and costs will vary on whether you've chosen a lawyer to do it for you or you're doing it yourself, and also will depend on the kind of lawyer you've picked, whether is depending on his cost. Although we have a general guideline on costs of lawyers, which is usually 2% of the value of the land you're buying. But if you're conducting this due diligence on yourself, then there are government fees that you need to pay, and the government fees are generally minimal. For The engagement of a lawyer, the best thing is to engage the lawyer not to just undertake the due diligence, but undertake the complete transaction, and therefore you'll be able to discuss fees which range from 1% to 2%. But of course, this will vary from the complexity of the matter and the involvement and the time taken by the lawyers. The other costs that are involved, transaction of transfer of this property to yourself, will include first, of course, the cost to your lawyer. There will be costs that are paid to the government, registration costs, and then there is the stamp duty, which is tax. Every land has a tax, and this will vary from one location to another. The rate for properties that are within the municipalities, that is the town, has been fixed at 4% of the value of the land, and the properties that are outside the municipalities, that are in the rural areas and areas that are outside the municipality, has been fixed at 2% of the value of the land. Obviously, the value is not the value that you have purchased the land, but it is the value that the government will determine as the going value of the land. What the government has done through KRA, they have posted the government valuers in all the registries. So the moment you apply to pay stamp duty, they will assign one of the valuers to value your land, either by physically going to the land or using the mapping that they have already done to tell you that the land in this locality, the minimum price is X amount. So you find in some cases you may end up paying 4% of a price that the government has decided as the value of your land, which might be slightly more than what you bought the land for. Recently, the government has operationalized what we call the Sectional Properties Act. This is a new act that has come into place so that owners of apartment will each have a title to their property. They will be registered with the county government to be paying rates and rents to the county government directly, instead of paying as a group of owners of the apartment. This is a new act that is still in its very infant stages of operations, and we already have seen several units that have already been converted to sectional properties. And therefore, what this means is that every owner of an apartment within a project gets their own title, and then an association or a corporation that comprises all the owners of the apartment is formed at the time of registration, and the owner of each apartment becomes a shareholder or an owner or a member of that association. Now, the purpose of this association is to collect service charge, manage the usage of the apartment, clean the apartment, provide security, and therefore the issue of payment of service charge and other services within an apartment has been given the legal backing, the legal strength by this sectional property. One of the biggest failures in apartments and gated communities has been the failure of some of the owners to pay for services that are provided and that are commonly used by the rest of the members, including themselves. But with this new act now, what we are seeing is that we have a legal backing now to collect service charge, and all the owners have a right to enforce the members of the association to pay service charge. And therefore we see that this is going to ensure that there is proper management of apartments. We will obviously see now the apartments will be properly managed, properly cleaned, and properly kept, because everybody will be paying their fair share of the cost of maintaining the building. With the Sectional Properties Act that has come into place, the first thing that happens is the land on which the property is built is surrendered, and new titles are issued for each apartment. And this can be used for borrowing of funds through the bank. You can take a loan through the bank, and this is as good as a title as any other title. And as Solian, one of the things we've already embarked on is to process sectional properties for our properties and our apartments. And we should be rolling out our first phase of titles of sectional properties in the next few weeks. Through the Constitution 2010, the government planned to scrap and has scrapped the 9,999 years leases, or any leases that are beyond 99 years. If your property is more than 999 years, then there is a process that has to be undertaken called the conversion of this property from anything beyond 99 years to 99 years. Now that process has not yet been, the procedure has not yet been adopted or has not been rolled out, and therefore currently what happens is that you still keep your title that is beyond 99 years as you wait for the government to start rolling out the conversion of all the leases that are beyond 99 years. What happens is that if your title, once the conversion starts and the title is beyond 99 years, then it will be converted to 99 years from 2010. From 2010, you will count 99 years. Now that has not yet happened, although it's in the process. Regulations have to be put. What is the process? How will you do the conversion? How long it will take? What document you will take? That has not yet been done. So titles that are still beyond 99 years are still good titles, and they are in use, and the registrars are still using them until the process of conversion happens. We of course have different kinds of titles. We have the leasehold titles, which are basically government lands which has given people leases on it, long-term leases that are beyond either 99 years. Some places like Nairobi, then you find 45 years, 50 years. In the coast region, the majority is 99 and 999 years, that is 9,900 years. Those titles are all in use, they are all good titles. Then we have the absolute titles, which are titles that are basically mainly in the rural areas and the peri-urban areas, which have no leases. Basically, it's an absolute ownership. You don't pay any rates to anyone. So the leases, if anyone owns a lease, then you pay some rent, an annual rent to the government that is payable annually every year at the beginning of the year. Of course, you can prepay the rent in advance, and these are all good titles. Then we have the sectional titles. So if in short, then we have like three types of titles. We have the absolute title, we have the leasehold title, and we have the sectional properties title. All these titles are good titles, acceptable by the government, acceptable by financing institutions, and they are good to transact in any property unit. So one of the things and one of the problems we've incurred is that when death unfortunately strikes, and then someone was in the process of buying land, or they just bought land and they did not transfer it, maybe none of their family members is aware of the process, then we've had a number of people lose their assets or properties through that means. At Solian, what we've done is that at the time of purchase, we insist and require you to let us have the name, the address, and the contacts of your next of kin. In the event we are unable to reach you or an unfortunate incident happening, we can track and trace your next of kin, advise them that you are in the process of buying property, or we are holding your title deed, or you're finished, and then we are able to assist you in the process of taking over the property that your kin was buying. Of course, this is a temporary arrangement because the process of succession is a legal process. Ours is basically to let the next of kin know that there is property that was being purchased or has been purchased by XYZ, and then therefore from there they will take the next legal process, which is take up the succession together with the rest of the other family members in accordance with the law of succession of Kenya. But as Solian, we would like to keep our word and ensure that none of our clients lose their properties or assets because of an unfortunate incident happening to them. They can rest assured that we will track and trace their next of kin and let them know the assets that we hold on behalf of our clients. The best advice we would give someone who is buying land in the coast, then I think the first thing is to identify the person selling to you so that you are sure that this person has dealt with land before, they know how to deal with it, and they are able to offer you support for your property, especially if you are off-site, you are not staying on the property. We advise mainly that the best case is buy property within a gated community or property that is already fenced, or property with a developer who is constantly on site, ensuring that they are taking care of the property. And they are constantly ensuring that we do not have encroachers. So it's always advisable that after you purchased your property, do not stay away for too long. If possible, post in a caretaker, fence the property, and ensure that the land does not become idle or abandoned, that some activity is ongoing. But we always advise then choose, if possible, where there is a gated community, some activity ongoing, then you can be sure that even when you are not there, your property is always taken care of, and the fear or the danger of encroachment has been completely minimized.